welcome to Legally Speaking with me, Tarun Nangia. Justice Suryakant, while speaking in Malaysia, has made some important comments on enforcement of arbitration awards, also on cost of arbitration and other related issues which he's spoken about. That we will discuss on the show today, but it was very encouraging for the business community because he linked the issue of rule of law, dispute resolution, ADR, which is alternative dispute resolution, with investments and business climate. It's so refreshing to know that a judge is thinking about this issue holistically. And, this gives us the opportunity to discuss on what he spoke and the larger audience to know what he's spoken about. Let me introduce to you Justice M.M. Kumar. Sir has served as a Chief Justice of the Jammu and Kashmir High Court. Earlier, he served as the Judge of Punjab Haryana High Court, then went on to become the first president of the National Company Law Tribunal, a very successful tenure, and now is a leading arbitrator. Good to see you, sir, and looking forward to some interesting insights. We have with us a gentleman who served as the Additional Solicitor General of India for a period of 9 long years, Senior Advocate Sanjay Jain, now practices at the Supreme Court of India, High Court, and other forums. Good to see you, and would like to know your views on arbitration, which you also do. We have with us Neeti Sachdeva. She is the Secretary General of the Mumbai Center for International Arbitration. She's in thick of all the action of arbitration. The good thing is that with her at help in the on the arbitration center, we've put Indian arbitration on the globe map. Arbitration centers outside of India have taken note of a lot of arbitration that has started happening in India. Good to see you, Neeti. At the outset, let me request Senior Advocate Sanjay Jain, if you could, in a few words, just reflect on what he said. Then we go to Justice M.M. Kumar for his comments on Justice Suryakant.
Tarun, as per the United Nations Conference on Trade and Development, that is UNCTAD World Investment Report of 2023, India has secured world's third highest FDI for new greenfield projects. And in 2022, and overall, India's receipt, so far as FDI is concerned, is 8th largest. It is as much a matter of rejoice as it is a sort of a hearing a warning bell, because if the arbitration awards are not timely and properly enforced, then this confidence shown by the investors may gradually fade away. Justice Suryakant's address in Malaysia ought to be understood in this context, that he has very timely indicated to all of us, the stakeholders in India, that we should pull our socks and do something meaningful to ensure that the arbitration hub that we are envisaging and we are visualizing that India should be, especially with such a robust rule of law and independent judiciary, we may not lose our priority or our primacy in this race.
Okay, thank you for the opening comment. We go to Justice M.M. Kumar. We've had the benefit of having you on the show earlier, where you've spoken very passionately about the interest cost, the other implications when resolutions are delayed. And this was in the context of your tenure at the National Company Law Tribunal. Now you are basically engaged in arbitration. So give us your view in relation to what Justice Suryakant spoke in Malaysia.
Thank you, Tarun. If you see the address of Justice Suryakant, it is referring to his own experiences in a case when his lordship was Advocate General Haryana. And what he says, that a matter which was hanging, it took half an hour to resolve. But in the next breath, he also says that it doesn't mean that I am favoring mediation over arbitration. Arbitration is going to envelop every branch of law. That is my belief. Mr. Sanjay Jain has given us the figure 2023, we are third. And if this trend continues, we would be facing challenges. In this very address in Malaysia, where the other person has talked about learning from Singapore, Hong Kong. But when it comes to India, he speaks limited way, in a limited way, if I may say so. Now, why it is so? We have to search for the reasons that why India has not caught the eye of the world, why Singapore is becoming more popular. We should be able to attract the best of the QC should come to our cities like Bombay. We have so many arbitration, very good centers, and in Delhi. Why Justice Suryakant appears to be suggesting that there are some deficiencies with regard to maybe efficient, it may be with regard to the quality of our professionals, so on and so forth. Cost-wise, I think nobody will be able to match India. We are very cost-effective. And although His Lordship has not delve on the cost part as far as India is concerned, but Singapore would be much more expensive than what we have in India. I'm sure Ms. Sachdeva would enlighten us on the issue of cost. But as far as I can see, India is much more cost effective than the centers like Singapore, Siak, and Hong Kong. Therefore, the second thing which I think Justice Suryakant has highlighted is a conducive commercial environment and rule of law, constitutionalism, independent judiciary. These aspects, now constitutionalism, for example, are the limitation on every organ of the state. If judiciary has done something, the parliament will not try to annul it. If parliament has done something and it violates the constitution, the presumption is in favor of the law enacted by the parliament rather than declaring it unconstitutional. Unless there are very, very sound reasons to declare a law ultra vires, while Supreme Court is very, very reluctant to declare a law ultra vires. So the constitutionalism, because if there is a very huge award, the parliament may take upon itself by passing a legislation. In past, it has happened. So therefore, His Lordship have talked about the constitutionalism also.
Yes. So thank you for your opening comment. I'll go to Neeti Sachdeva, Secretary General of the Mumbai Center for International Arbitration, and with her introductory comments, she'll reflect on Justice Suryakant's speech and the points he made in Malaysia. What do you think?
Thank you so much, Tarun. Firstly, I must thank you for inviting me. It's great to be here and to be interacting with such august gathering. I think my other co-panelists, if I may say, Mr. Sanjay Jain and Justice Kumar, have reflected on some aspects of it. What I want to pick up are the different other remaining aspects of what Justice Suryakant spoke so succinct in her speech in Malaysia. And I think one of the very important factor he said that is the cost effectiveness, but you should not forget about the timely conclusion of the matter, and the two have to run hand in hand with each other. He again spoke about also the minimalistic judicial intervention, which coming from a Supreme Court judge clearly shows that how our judges nowadays are thinking about it. And I would say have gone a step ahead to do their promise of putting India on a global plane for being an arbitration friendly jurisdiction. Whether you look at their judgments in Cox and King or other judgments in NN Global as well, I think the judiciary has played a very, very important role in building that atmosphere, what Justice Suryakant spoke about as well. I think another very important aspect and very close to my heart, I would say, is that what Justice Suryakant spoke of was about joint coordination among institutions, and I quote him for that. And I think it's commendable to see, if you look at the last 2 years. I would say last year that we had the Delhi arbitration weekend, then we had the India ADR week, which were basically to celebrate India as a jurisdiction for arbitration and ADR. And both these events, which happened in Delhi and across India, saw participation of more than 40 different arbitral institutions across the globe. So clearly what Justice Suryakant was, adhering to say that there has to be a coordination. I think somewhere, look at the Delhi Arbitration Center, look at the MCIA, NPAC, ICA, they've all realized it and are actually now don't think of themselves as competitors, but I would say more as facilitators to make sure that India rises up to be the place to resolve dispute. Very quickly, just one last point, Tarun, before of course we hear our other panelists. I think what's also important for us to consider is that I think it's an unfair comparison when people say that why India is not able to do something what Singapore has been able to do or Hong Kong has been able to do. And for the ones who have heard me before, I'll just, sorry for the repetition, but I want to take this to say it, is that Singapore is only probably as small as your South Delhi or south of Bombay. To compare a jurisdiction that small to say that something happens in Singapore, why doesn't happen in India? I think we're a large jurisdiction where you have judiciary coming up with different judgments across, but we have done fairly well for ourselves to be out there and say that come invest in India. We will resolve your disputes quickly. We have a judiciary which is supportive and a legislation which is, all enabling.
Thank you for that opening comment, Neeti. The underlying message from Justice Suryakant I can see in 4 points. First would be pro-enforcement of arbitration. Second, as you highlighted, minimum interference from the courts. Third, also he linked it to investment and the investment climate. So he's linking all this to business and to growth of the economy. I'll go to Mr. Sanjay Jain. Mr. Jain, you have the unique experience on arguing from both sides as the Additional Solicitor General of India, now as a senior advocate who is representing many private clients. If you could share with us your experience on why Justice Suryakant spoke in favor of minimal judicial intervention in awards and the relevance of the statement.
See, the minimal judicial intervention in awards is something which is the need of the hour. Because if arbitration regime has to be sustained in India, then we have to understand that it is the parties who have chosen a particular tribunal to adjudicate the disputes amongst themselves, between themselves. Once the award comes, then the proceedings cannot be challenged or the award cannot be challenged as if you are taking an appeal against it. What is contemplated under our Indian Act is only an objection, which is in alignment with all other international enactments of similar nature. So when it comes to the objections, there also, if the courts would start supplementing their views and trying to, and if they will start trivializing the rationale or the reasoning given by the arbitrators, then it will lead to complete chaos. One thing is very much clear, that 34th theme has to be pressed into service with extreme care and wariness. Apart from that, the other aspect which Justice Suryakant's speech reflects is this, that he is extremely conscious of the fact that the execution of decrees in this country takes long time. And that is something which directly affects the environment or the ecosystem of international arbitration when it comes to the enforcement of the international awards. Long back in 1872, Privy Council had observed the difficulties of litigant in India begins when he obtains a decree. So these awards are like decreased now under the new act. So therefore, the situation has to be understood. It is not the same as 150 years back when 1872 Privy Council made this observation in Raj Darbhanga versus Maharaja Kumar Rampat case. But today, situation of course has improved, but still there is a lot to be done. And it is in this context, Justice Suryakant's observation become extremely important, because if you see last 1 decade Supreme Court judgments, without mincing words, Supreme Court has said that in the matters of international arbitration and their enforcement, there is a pro-enforcement bias. Now, somebody may say that the expression bias is antithesis of a judicial system. But no, we should understand the letter and spirit, and which is what Justice Suryakant wants to point out. When he says that, look, you have a robust legal system, you have a rule of law, you have an independent judiciary, then is it that judiciary is to be blamed altogether? He is actually pointing out that the other stakeholders are also lagging behind. They are not doing their homework properly. And in this speech, what he is pointing out that he has used a very interesting expression. He has used the expression judicial consciousness of Indian judiciary. What he is saying is that so far as Indian judiciary is concerned, it is already conscious of its obligations. It is the litigant, it is maybe the award holder, the decree holder, who is lagging behind, who is not doing his homework properly. If you dig deeper, you will find that all those enforcement proceedings, which are languishing in court for a long time, it is not for the reason because the court is lagging behind. It is for the reason that either the legal team of the decree holder is not making a proper strategy. They file execution petition without doing their homework as regards the assets of the judgment debtor. And these are the things which need to be rectified and improved. And because it's not being done, actually is bringing a bad name to India's ecosystem, for which Indian judiciary is not responsible. Other stakeholders also have to realize their responsibility and become as conscious as Indian judiciary is. This is what I think is the hidden message in Justice Suryakant's address in Malaysia.
Thank you for decoding Justice Suryakant's speech, Mr. Jain. I'll go to Justice M.M. Kumar. I would like to know from you, again, the point that he reiterated of minimal interference in arbitration awards, and reflect on the importance of the statement.
Well, minimum, this is a universal slogan, that minimum interference by court. But we have section 34(2) in domestic arbitration award. We have section 44. Grounds are specified. So on those grounds, the High Court or the Supreme Court will be well within its entitlement to interfere, unless a new convention is created. New York Convention, you see, is the basis of section 44 and the limitation which have been given. Having said that, I would agree with Mr. Jain that Indian courts are not interfering on a throw of a hat. On a very substantial issue, interference comes, and very little. Mr. Deva has referred to 2-3 judgments of the Supreme Court to advance the argument that interference was minimum. I wish to highlight another point. As a president, National Company Law Tribunal, I had a chance to go to Singapore and interact with the judges there. In the matter of insolvency and bankruptcy, where multiple jurisdictions are involved, JIL, a coordinating effort by the judges, has been evolved by Justice Ramesh Kannan of the Supreme Court of Singapore. And there, when multiple jurisdictions are involved, property is situated in US, UK, India, then the judges sitting from all the jurisdictions participate, and then decide. Cross-border. So JIL has been evolved. So similar coordination amongst the judges in respect of arbitration can also be, and Ms. Sachdeva has rightly emphasized this issue. And I believe that similar effort on those lines could be made. They have named it JIL. This arbitration coordination committee at international level can be created, particularly when multiple jurisdictions are involved. So I will also point out that in order to, Justice Suryakant has emphasized that in order to attract investment in this country, the enforceability of the award has to be more efficient, has to be more efficient. That is what he wants to emphasize. And I would say, no, I know one case where an Indian judge in Singapore court was found napping. And the QC who was arguing the matter, he said, kindly record that the judge was napping, and the judge refused to relent, and in fact wanted that the video which was running, that should be taken off, and that part should be taken off. And then the QC insisted that no question, it cannot be taken off. Then the judge left the arbitration. A new judge has to be appointed from India. So if such like things happen, it tarnishes our image. We must, as I think both the panelists have would agree, that we have to pull up our socks. Question of sitting in foreign jurisdiction by an Indian judge, I think that should be taken very, very carefully, and only they should be able to deal more efficiently with the such like impression create problems. I am not criticizing anything, but I am just bringing forward a point which has actually happened.
But thanks to you, we also get some anecdotes on every show. We can,
that is true.
I'll take this to Niti Sachdeva, Secretary General for the Mumbai Center for International Arbitration. Niti, Justice Suryakant spoke about timely conclusion in arbitration. Could you reflect on his statement?
Sure. I mean, again, Tarun, I don't have an anecdote, but something which really happened. So, in 2015, we have our act which was amended. And the act said that we have to finish our arbitrations in 12 months plus a 6 months extension by party, so 18 months. And it so happened that, MCI was just created around the same time. And I was in London addressing a roadshow and talking about what's happening in India and what we are doing. And this was a room full of London lawyers. And, they came up, they did not want to listen to anything else. And they picked up this topic of timely conclusion. They said, Niti, you have a situation right now where arbitrations take anywhere to 3 to 5 years. And you are now talking about 18 months. So how is that going to happen? Right? Of course, I didn't have any empirical data at that time to tell them that we're going to, do it. But I'm an eternally optimist, an eternal optimist when it comes to arbitration for sure in India. So I told them, I said, listen, we have definitely swung the pendulum the other way from a 5-year to an 18 months. But I'm very confident that the diaspora, which is working in Indian scenario on arbitration, is all geared up to make this happen. And fast forward ourselves in the next 5-6 years, right? What have we seen? We have seen that we saw arbitrations. I wouldn't say all 100% happen, but that don't happen anywhere in the world. I would say almost up to 80% of our arbitrations got resolved in 18 months' time. We saw arbitrators who were accepting 60, 70, 80 arbitrations as an arbitrator stopped accepting them because they became accountable. I have had an experience where a very seasoned arbitrator was approached and he said, sorry, I already have these many matters. I don't think I can finish in 18 months' time. I will not accept it. And then that saw Delhi High Court, Bombay High Court playing such an active role to appoint first-time arbitrators. And they've done a fantastic job. So I think, when Justice Suryakant talks about it timely and he says that you link cost to time, he's absolutely, on the point of it to say that you have to reduce the cost, but at the same time, you have to make sure that the arbitrations happen in a timely manner. Now, of course, our legislation has done its bit. I think institutions are doing their bit as well to, have a whip on the arbitrators to make sure they do it. But I think it is our lawyers as well and the litigants which need to stop using all those antics to try and derail the process. It's not going to help anybody. So if you look at, that is what I remember when I was a student of law. At that time, Mr. Nariman spoke about having an arbitration bar. And we're still I'm now 18 years into practice, and we still haven't really seen a dedicated arbitration bar. So you have lawyers practicing in courts coming to court and saying, sorry, I can't do an arbitration, or I cannot do a court work because I have an arbitration. And that derails the process as well. So I think Mr. Sanjay Jain was very point on to say that Justice Suryakant has made a very pertinent point that judiciary is doing its bit. I think it's time for us to pull up our socks and do it. I think institutions are doing their bit, lawyers need to do their bits, litigants need to understand as well that they need to put a stop to all of this. I think, Tarun, one more point I'll make here is that if you look at what legislation, of course, has done, but also what the government has done. So if you've looked at that policy of Vivad to Vishwas, second policy which came by, where they're saying that if you have an arbitration award against a government entity, right, and they've given tabular form of it, that how long an award has been pending, what is the amount involved, a private contractor can go on and negotiate, literally and negotiate with the government entity, get paid up maybe 70%, 60% or 80% and continue with the business. I think that just reflects the mindset where even the government is looking at, if there's an award against them, it is not that they want to derail the process of giving up the money. But if they find a value in it, they're happy to get payments done, business to run. Ultimately, that's the whole purpose of arbitration.
Points well made. I'll go to just Sanjay Jain, senior advocate. Mr. Jain, two things. When Justice Suryakant spoke on timely conclusion, could you also reflect on the same as Nitin?
Yes, when he says timely conclusion, invariably he is linking it with the cost effectiveness. Because knowing Justice Suryakant has always been a pro-citizen judge, and he always thinks it from the angle of a common man who is a consumer of the justice delivery system. So if the cost of any procedure is high, I mean, arbitration is not meant only for the multinationals or the government bodies who have deep pockets. Arbitration as a remedy is also contemplated for a last man on the street. So when he speaks about cost effectiveness, it is intricately linked with the expeditious disposal of the proceedings. And I agree with Justice Kumar when he says that Indian system is not very prohibitive in terms of cost. But I believe when he's speaking about the arbitration proceedings and the fees of the arbitrators, there I may agree with him. But if you see, if the matter goes for a very long time, then you visualize the situation, Section 9, then Section 11, or then arbitration proceedings themselves, and then a challenge. And if it comes to international arbitration, then of course your Section 48 has only 7-8 grounds on which the award is to be tested. After Sleepwell case, it is a one-stage process. So judiciary has done its bit to make it simpler for you. But one reason, the absence of a dedicated arbitration bar. And second reason, the overall culture in appreciating that this particular regime of arbitration is coming as an alternate dispute resolution forum. So we cannot treat it the same manner with same kind of a easy go, happy, lucky attitude that it may take its own time, doesn't matter. So we have to be actually a little more serious about it, and we can introduce in the statute itself some kind of incentives for early resolution of the awards which have been passed, maybe in terms of a lower interest rate or some other kind of incentive. which can be brought in by a statutory regime, which may ultimately address the concerns which have been raised by Justice Suryakant in his speech at Malaysia. Because when he speaks about cost effectiveness and the long duration of the litigation, this is where, according to him, and I agree with him, because this perception, because ultimately it is all a battle of perception. If this perception continues, then a foreign investor also would feel that, look, if I put my money in India and ultimately if I have to go in a dispute resolution, even if I will have a decree, it would be a paper decree, which I may not be able to execute for long years. So therefore, all the stakeholders, whether it is a contractor here, or it is a employer here, or whosoever is the litigating party in an arbitration, and all other persons. And therefore, in my view, the discipline which is being talked about by my learned panelists here can be achieved in a greater degree if we encourage more and more institutional arbitration, because institutions properly regulate the progress of a matter. And with that kind of regulation, it is not left to the arbitrator or the tribunal itself to regulate. Because if it is not an institutional arbitration, all administrative work is to be done by the tribunal members, and they will not be able to find time to ensure that much alacrity or expeditiousness in the whole process. So we actually need to have a holistic view of it.
Point well taken, Mr. Jain. And we're almost out of time. We just squeeze in one 30-second, 45-second comment from Justice M.M. Kumar. Given that Justice Suryakant, who's in line to become the Chief Justice of India, has made such a statement in favor of arbitration, you see that a lot more will be done in near future?
Karan, I wish to point out that in domestic arbitration, the period has been prescribed 1.5 years. 6 months for pleading. Even that was not liked by Justice Merriman. When the amendment came, he was very, very critical of that. In one of the lecture which I heard, he bombarded like anything that what is the use of giving the 6-month period. Anyway, but in the international arbitration, we don't have even any such limitation. I was wondering whether any period could be prescribed for finishing the international arbitration. And same thing, I would say, cost effectiveness. There is no Schedule 4 for the international arbitration. So these aspects, I think, need to be pondered over. It is for all of us to impress upon either the legislation or judicial intervention, because in international arbitration, what I have seen, 7, 8, 10 years. Some of the arbitration have gone up to 7, 8 years. And the lawyers are also at leisure. They don't feel the burden of finishing it. Whereas many of the arbitration, on the basis of documents alone, award can be announced, argument can be advanced. There is very little scope for oral evidence. Second aspect, I think the arbitration bar. Now, Mediation Act has been passed by the Parliament. The mediation bar, like the Bar Council of India, would be a separate bar.
Yes.
Now laid down. So why can't we have the amendment in the Arbitration Act saying it will not be evening session of arbitration post 5 o'clock, post court hours? I have been doing arbitration. I keep cases at 11:30 in Niti Bagh. No, 11:30, some of the counsel, they say, we will not be able to come. I would insist that, no, you make your arrangement. It is not part-time job. It is a full-time job. But still, some of the counsel agree. They come and argue at 11:30. But I must confess that 70%, 65% cases are still post-lunch. So if the arbitration bar develops, then this culture will vanish.
Yes.
My
Point well taken. We're almost out of time. On the next show, we get to discuss more. But I would like to thank Senior Advocate Sanjay Jain, Justice M. Kumar, Neeti Sachdeva, Secretary General NCIA, for sparing time and joining us on for this important show on what Justice Suryakant spoke in favor of arbitration. Appreciate your joining us. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.